progress.
Am I audible to all of you? Am I audible? Everybody?
Yes, sir.
Am I audible?
Yes, sir.
Right. So, guys, today we're going to start with the judiciary. Okay. Before starting with the judiciary, I want to tell two things. One thing, how many of you are aware that Devinder Singh judgment has been passed and the judgment is now pronounced, basically? Anybody is aware? State of Punjab is Devinder Singh, which we were awaiting. Anybody who's aware? Not really. Okay. So, yeah, sir. Tell me.
Yes, sir. Sub classification is allowed.
Classification was already allowed. It
They
was
overruled the E.V. Chenaya judgment.
yeah, E.V. Chinaya, it was overruled. It was basically that was the law. E.V. Chinaya was came before, and after that Davinder Singh came, and Davinder Singh basically overruled or tried to overrule, which with the same 5-judge bench, E.V. Chinaya, and now 7-judge bench, Davinder Singh came. Good. Now, another 500-page judgment. Okay, that's a very important thing, but interesting one, definitely. We are going to take up that particular judgment because ऐसा तो हो नहीं सकता कि रिजर्वेशन के बिना आप लोग क्लैट पीजी देने के लिए जाओ, ठीक है? Yeah, Venkat. Anything that you want to say? So, this is a very interesting thing because when you were going to go to Devinder Singh is the recent one, 2020, and again Devinder Singh, State of Punjab, 7-judge bench, that is dictated. Now, the important part is that you just need one judgment to read every judgment. And when that judgment is of 565 pages judgment, I was going through it, D.Y. Chandrish has written. Okay, Bela Trivedi has probably given the minority judgment. You have to read it from the N.M. Thomas, from the 1975 onwards. Interesting. And the thing is that the judgment would be very important for the CLAT PG 2025 purpose, definitely. And for your understanding, we're going to do that next week. Okay, we're going to start with the judgment because I was waiting for some kind of, because I don't want any 500 pages judgment to be taught in the month of September, October. मैं नहीं चाहता हूँ October में, ठीक है? Because that time there will be quite a lot of things are going on in your mind, okay, and a lot of revisions to be done. So it's better to be read now, the any 500-page judgment, okay. So that's why next week I'm going to, as usual, the 9 p.m. Thursday, Friday will be slot will be taken for that, okay. But interestingly, Davinder Singh we have to study. So a lot of things are there. Even Maratha you have to understand for Davinder Singh. The beauty is that to understand Davinder Singh, you have to understand minimum 9 to 10 judgments. Minimum. It's not like Article 370. It's way bigger than Article 370. I'm telling you. Okay, it's not like Article 370. Okay, it's bigger than Article 370. But nonetheless, when you're going to learn that, it will be very, very interesting and very uh, when you were going to understand the Article 16 along with Article 341, 342, the Maratha one, the recent 10, Second Amendment 10, Fifth Amendment, all those things are very if you understand the reservation, I don't think so in your lifetime again you have to look back. Again, you have to look back in the reservation. Okay. Uh, so we had the opportunity to read. Definitely we're going to read. And another 500-page judgment. So this one thing that we're going to start from the next week. Another thing I wanted to tell you, so many of you probably having some kind of productivity issue going on in your um, preparation. Any one of you facing productivity issue, facing like you are not productive enough in a day, you might be more productive. Anybody? Can you type yes if you are facing or if you are thinking like that? Okay. Acha. Anybody is thinking somebody is not productive enough? कुछ बोले सर मैं प्रोडक्टिव हूँ आप कुछ भी बोल लो आई एम द बेस्ट राइट नाउ नहीं ये लाइन सुनने के बाद सबको यस कर रहा है सर नहीं नहीं अभी आई एम नॉट प्रोडक्टिव सर ओके so for you guys this book might be of great help. I don't think so you have this book. If you have, it's a very good book. If you don't have, it's a very small book. Do read it. I don't know you were able to see that. This book name is Eat That Frog. दिखाई दे रहा है आप लोगों को? मेरा बैकग्राउंड ब्लर है तो प्रॉब्लम नहीं दिखाई देगा. यहाँ से दिखाई देगा. ठीक है. Eat That Frog. Anybody having this book? Anybody having this book? Vaishnavi has. Okay, बहुत बढ़िया. So if any other people doesn't have it, okay, do have this book. It's a very small book. This book is not popular in the legal domain, definitely, because this book is written by one entrepreneur, and as I'm an entrepreneur, so that's why this book was. I know Brian Tracy for so long, for the probably last 8-9 years, and I have been following Brian Tracy for so many years. Now, you can have this book, Brian Tracy. Okay, Brian Tracy. Okay, Eat That Frog. You will type Eat That Frog. Is so uncommon name of this book. Eat That Frog. सर क्या मतलब कुछ भी मेंढक खाने के लिए बोल रहा है सर. हाँ. But that's the main fundamental of this book. Okay. So इसका main fundamental यही है. ठीक है. Do have a proper read. It's a very very small book. मतलब आप ये this book is of 100 page. मतलब 1/5 of Davinder Singh or Article 370. 1/5 of Article 370. Even not even that. क्योंकि ये छोटा साइज का है. वो तो ये 4 साइज का आता है. ठीक है. It's hardly 1/5 of Davinder Singh that you people are going to read, and I don't find कि ये पढ़ने में आपको ज्यादा टाइम लगेगा. Okay. So do have a proper read. Okay. And the main thing is that whenever you are going to start with your work, okay, every day, the most important and the most crucial task, you have to start the first. Okay, that is the main crux of this book. But how you're going to manage the other thing, that is also written. Okay, Eat That Frog means frog is the biggest work of the day. Okay, that is to be done that day first. और सर एक ही फ्रॉग खाने में दिन चला जाता है. उसी फ्रॉग में सर So how can I complete the whole task? But please do refer if you have anything that if you want to complete, be productive. It's not only for it's not only for your it's not only for your college time, okay, but also after your college, if you are working professional, this book is highly recommended, okay, because this is written for the working professional. As you are a student, probably this is not for you, but this book might help you in this case, okay. Chalo, these are the things that I wanted to share with you. Now let's jump onto the judiciary. Now before sharing with the or getting into the judiciary, I wanted to ask, who is that here? So no, 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 it's actually no. What was said in this book, could you summarize? नहीं, आपको अगर समरी जानना है तो यूट्यूब में भी देख सकते हो आप. At least I want you to go through some of the principles and the tricks of this book. It will help you, Sahib. Okay, okay. So, chalo, let's get into it. And I'll not spill the beans regarding this book right now because otherwise you'll not read this thing, which I want you to read basically, or I want you to go at least get a summary of this book. ठीक है, summary of the any YouTube videos that you will find, because अभी बहुत book का summaries मिलता है. ठीक है, आप वो summary देख लो, that will help you a lot. अच्छा, अभी let's get to the next part. Yeah, Bhavika, do you want to say anything? अच्छा, nothing. ये देखो, ऋषभ जी ढूंढ के अभी दे दिया. I was hoping you would solve the problem, but you gave another big task. देखो ये ऋषभ ऑलरेडी खोज के इसका तुरंत दे दिया. चलो पीडीएफ दे दिया ऋषभ ने. You don't need to buy them at least. चलो. Now coming to the next very important part today, what we're going to get to this judiciary. Okay. Now before getting into the union judiciary, I want to ask two questions to you. Okay. The judiciary is one of the important pillar of our democracy. Okay. Now, India is one of the country where judiciary is given very much importance, very as a third pillar. The reason being, judiciary is one of that important pillar in our democracy, which check and balance with the other two pillars, executive and legislature. Now, this particular institution, judiciary, has been given a lot of power under Indian constitution, lot, really lot. Okay. And though the power which is given under Indian constitution to judiciary might not be that explicit, but judiciary somehow managed to take it by their own interpretation, the power that they owe, or you can say for the sake of independence of the judiciary, they basically gathered. We are going to learn how much judiciary or how much independence of the judiciary is given in relation to Indian constitution, and how much they basically accrued by their own interpretation throughout the decades, last 4 or 5 decades, how they basically interpreted in their own favor that their independence of judiciary is getting or should be upheld. इसके बारे में हम लोग टोटल डिस्कशन करेंगे. बट बिफोर दैट आई वांट यू टू tell me two very, other than the union judiciary that is going to start from article 124, tell me two very important articles which are related to Indian judiciary or the independence of Indian judiciary. Anything there? Any one article that you can remember or tell, which gives lot of power to Indian judiciary? Any one article? अच्छा, अब स्टेट जुडिशरी में चलेगा, यानी स्टेट जुडिशरी छोड़ के, स्टेट जुडिशरी वाला पार्ट एंड दिस पार्ट यूनियन जुडिशरी वाले पार्ट छोड़ के, टेल मी.
Sir, it's Article 50, which talks about
Article
the separation of
142.
power.
बाप रे बाप.
So
अच्छा,
142.
एक करके बोलो. Yes, 1 second.
Sir, Article 50, which talks about the separation of powers. Sir, which gives the doctrine of checks and balances.
Okay. Article 50. What is the another article? Any other article that you were aware?
Article 142. 142. Chief Justice.
पिछली के अंदर ही आ रहा है आशा जी. I told exclusion of union judiciary and state judiciary.
Sir, it's Article 13.
So whatever, yeah.
Tell me. Article
So I
13.
was about to ask a judicial review. Yeah.
Yeah. Sanmukha, what you were saying? Article 13.
Yes, sir, about judicial review, I'm saying.
How that is given power?
No, sir, actually, but Article 13 mentions that any law inconsistent with the constitution, that way is told.
Okay. So Article 13 and another is Article 50. These two articles, other than the union judiciary and this, definition of law, definitely purpose. But other than the definition of law, the judicial review is one of the part that I'm basically taking here. Because any law which is inconsistent with the fundamental rights or taking away fundamental rights, that law has to be taken away, or judiciary is given the power to basically strike down that law. Now, this power is a huge power given to judiciary. And that's why, as this power is given to judiciary, judiciary has to be neutral, or judiciary has to be totally independent. Otherwise, exercise of this power is highly improbable. The reason being, suppose this judiciary is corrupted or judiciary is manipulated by executive, then in that situation, it is very difficult that any law which is passed by the executive or the parliament might not be struck down or might get the favor from the judiciary, otherwise might get struck down if they are independent. Okay. So that's why the independence of judiciary is one of the very crucial factor of Indian democracy, because that will lay down the foundation of proper checks and balances with other two pillars. And executive and legislature, they cannot basically go ahead with their powers and dictate the things. Judiciary can get into the situation and take and tell the other two pillars anytime that this is your domain, please stay within that domain. And in some of the cases, I might enter into that domain too. Okay. Some of the cases, because there are so many instances like Visakhapatnam was a state of Rajasthan. Okay, where there is no law and Supreme Court has given the guidelines in regarding that. Okay, Supreme Court is creating the law for the next 10, 15, 20 years for the sexual harassment at workplace. So in some of the cases, Supreme Court might enter into the domain of the legislature or sometimes enter into the domain of the executive to carry forward the task or take the task. Okay. So this is the situation with the independence of judiciary and the judicial review. Now, so judicial review, as I have told, and I have told many a times regarding the Indian Constitution, okay, And independence of judiciary is one of the very important facet of our Indian Constitution. Okay, these two very important part cannot be forgotten, because these two very basic principles are ingrained in Indian judiciary. Okay, one is this part, आपके judicial review and independence of judiciary. Now, please open Article 124, everybody. Okay, and we're going to start with the Union judiciary. And we are going to start with the very important aspects of today's class. You will understand and love some portion of it. Okay. Chalo, Article 125 kholo or start karo. If it's done, sir, which all sections 13 and 15? 13 and 15. Sections nahi, articles here. 13 and 15. 13 and 50. Yeah. Please open your textbook, Article 124. If it's done, to let me know it's done on the chat box. And I'm going to open on the Google 124. Start reading the Article 124, and we are going to get to the next part. Article in Constitution. Royalty is not a tax. That judgment, how many pages judgment that is? I haven't seen the page, the length of the judgment, basically. Anybody has gone through that judgment? What is the length of that judgment? Anybody is aware of that? If it's done, let me know down. Okay, much. Done? Achha. Okay, बहुत बढ़िया. Sir, about 350 pages. Okay, sure. Problem. Is it visible to all of you? Is it visible, everybody?
Yes, sir.
Now, Article 124. Article 124, the first 124.1, it's a very simple thing. Okay. Now, 124.1, if you see it, there shall be Supreme Court of India consisting of a Chief Justice of India until Parliament by law prescribe a larger number or not more than 7 other judges. So, it's a basically, there shall be Supreme Court of India, which is the first important part that is stated in Article 124. And then the next part, it is said that Parliament may by law increase the number of judges. Now, when you're going to start reading the Article 124 Union Judiciary, one of the things I want all of you to take a look at it, there is a huge conflict or a huge power struggle or tug of war that you are going to find in the Union Judiciary portion with the executive and judiciary. Huge tug of war. And we're going to find this thing. Okay. And this number of judges was increased in 1986 once, then 2008 once, and it is basically, it was done several times. Okay. And this particular situation, the Supreme Court of India came into being on 28 January 1950. That was the time period. Okay. It is hardly the first CGI was the H.A. Kanya was the first CGI. So these are the very simple fact regarding the 121 that you need to know. But that's not our point of view to understand here. Main game starts from the 124 2 onwards. Okay. Because here this is the older thing, right? It's National Judicial Appointments Commission is mentioned. Right? This is the old article is there, right? It's not the new one. Or even the old one also there. It is that time when no, ये नहीं चाहिए मुझे, ये नहीं चाहिए. ये क्या है? What is that? This is something else, right? This is not excellent. I want that particular previous article, not related to NJC, because NJC is not there currently. This is the current one, right? Right? Yeah. Now, I'm taking by this, okay? The reason being what I found in the India Kanun, it is the after 2015 99th amendment के बाद जो आया था उसका मुझे मिला, okay? This is not the current law, okay? This has been struck down in the NJC. NJC has been struck down, तो NJC है ही नहीं तो उसको बोलने का कोई मतलब नहीं बनता, okay? Now let's talk about it, or even Article 124 in your bare text, you can open it up. Where is my okay, whatever. So every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after the consultation with such judges or Chief Justice of India, also there, of the Supreme Court and of the High Courts in the states. Now, here, this is the very first thing that you need to understand, and this is where all the things regarding the Union Judiciary and the executive started. 124.2 basically talks about President, after the consultation with the judges, is going to appoint the judge of the Supreme Court. Right, guys? Is it clear by this? Shall hold office for 65 years? I'm not worried about that particular thing. But what this first two sentences of 124.2 talks about? What is the first two sentences of the 124.2 talks about? What is the first two part of this thing talks about, guys? Is it clear that after the consultation with the judges, here the judges of the Supreme Court is there, then the judge of the Supreme Court will be appointed. Suppose here in this case, the judge, CGI is going to be consulted along with the president to make appointment for every judge of the Supreme Court. This is the main point of contention throughout the history for the last 1975 to 2024. Kitna time ho sakta hai? 1973 to 2024. It is 50 years, if I say so, around 50 years. The point of contention with the executive and the judiciary with this 124.2, this president after consultation with the judges. Now, what is the contention and how this thing happened? Let's talk about it, because that's where the power struggle started. That's where who have the higher say. President has the higher say, or the judges of the Supreme Court has the higher say in relation to appointment of the judges. Are you getting it? Are you getting it? What is the situation? Who has the higher say? Now, if I start saying this particular power struggle, okay, in this power struggle, you need to understand what you have to understand. You have to understand one very important phenomenon. This is getting started in the 1973, 25th April. मैं थोड़ा हिस्ट्री में लेके जाता हूं आप लोगों को एंड वहां से मैं आप लोगों के साथ बाकी चीज एक एक करके शेयर कर रहा हूं. This is started in 1973, 25th April. Sir, what has happened on that particular date? This is a very unique date, and this is the date where the first power struggle started with the union and the union judiciary. But if we go back to another 23 years after independence, was there any struggle regarding this appointment of judges? Not really. Not really. Because 23 years after the independence, till 1973, everything was going on very, very smoothly. The senior most judge became the Chief Justice of India. That was the norm, and everybody was expecting that. Now, 1973, or not really 1973, it started from the Golaknath case, 1967. From the 1967 onwards, union or the executive for the first time, they started basically downplaying the judiciary for the very first time. And they saw the judiciary is not the institution who can be controlled. A judiciary is that kind of institution that might curb the power of executive. 1967 in the Golaknath, for the first time they faced it. How? For the first time, 1967 Golaknath judgment, Justice Fazal Ali told, and he was very vocal in this case, the fundamental rights cannot be taken away at any cost by any law. Okay. And then that particular ruling of the Golaknath, very first time, just shook the executive from the very core. Look, what has happened? We cannot make the law to take away fundamental rights. Okay. Now we have to be very careful what kind of law that we are making. Okay. From the 1967 onwards till 1973, Kesav Nanda Bharati. 1973 Kesav Nanda Bharati somehow overruled the Golaknath, but created another very distinct feature in Indian Constitution, that is basic structure of Indian Constitution. And it stated in Kesav Nanda Bharati that executive might take away the fundamental rights, but cannot take away the basic structure of the Constitution or basic feature of the Constitution by any constitutional amendment. A very big thing that time. It means the constitutional amendment cannot basically take away the basic structure. It means executive has a periphery to work in. Executive cannot do anything with the constitutional amendment, which they were planning to do basically that time. Kesav Nanda Bharati given that particular judgment, okay, and then the next thing followed. Next thing is simple. Next thing is first supersession of the judge. In 1973, what happened is the first supersession of the judge. Okay. Yes. First supersession of the judge. ये क्या आ गया? गजब. Right? That's the best choice. 1973 for the first time, first super session of the judges. अच्छा एक सेकंड, ये कहाँ गया? एक सेकंड. First super session of judges happened. Super session, sorry. It's now what basically happened for the first time? Executive started appointing the judges who is more favorable to their ideology, or they are favoring the executive more. And A.N. Roy superseded 3 senior most judges that time and became the Chief Justice of India. And how it is happened? For the very first time, as per the law stated, President, after the consultation with such judges or the CGI, whatever that, okay, such judges of the Supreme Court of India, they appoint the judge. So President only consult with such judges of Supreme Court. So President has been given the power to appoint Supreme Court judge. Now, actually, President doesn't have any power. Who has the power? The executive. As per the 74-2. So, in the 74-2, executive or the cabinet, they are basically favoring those judges or appointing those judges who are going to help them in that particular institution. And for the very first time, it shook the core of Indian judiciary, and they realized if this is going to continue again, then Indian judiciary or the institution, judiciary as an institution, it will lose its independence down the time. It will be a mere plaything of the executive. That was the first instance. Then, after this thing, another very infamous case came to Supreme Court. And Supreme Court was always ashamed of this case when they open the history. That is ADM Jabalpur, habeas corpus case. Okay. I hope many of you might have heard this case named ADM Jabalpur case. Yes or no? Right? Yes.
Yes,
ADM,
sir.
yeah, Aisha, tell me. Tell me.
HR Khanna's dissent, sir.
Yes.
Yes, sir, I know the case. HR Khanna's dissent.
Yeah. So ADM Jabalpur case. ADM Jabalpur case, it was a case, it was very infamous case. Infamous case because the Supreme Court that time, because during the emergency, the fundamental rights were taken away and people were unlawfully detained. And Supreme Court agreed with that you are not going to have any kind of fundamental rights during that time, emergency. Now, in that particular ADM Jabalpur case, there is one particular judge, especially he is very famous because of his dissent, H.R. Khanna. H.R. Khanna went against the whole situation. And he stated fundamental rights again. There are some fundamental rights cannot be taken away during the emergency, which led to incorporation of some articles cannot be taken away during the emergency. Can you tell me the article? In which article it is incorporated? In the emergency provision? That these two articles cannot be taken away. Open it, check कर लो, revision भी हो जाएगा आप लोगों का. 359. Open that article. What are the fundamental rights articles that cannot be taken away? That is written in the. Open it. एक बार check कर लो. Article 20 to 21. And what is the emergency article that is written? Everybody got it? 359 article 20, 21. Article 359 में लिखा हुआ है article 20 and 21. That is to be checked. Now, after this judgment, ADM Jabalpur, HR Khanna was superseded again. Again, this particular thing pierces the heart of judiciary. Second time. Well, what is happening? The independence of judiciary again shaken from the core. In HR Khanna superseded. HR Khanna was needed to be CJI, okay, because his understanding is. I was reading some of the books, okay, and while he was writing the judgment, okay, that time I was reading one of the book. I don't know what is it. It is Police Nariman's book or something. मुझे याद नहीं आ रहा है, ठीक है. I was reading that book. He was basically, while writing that judgment, that judgment is not pronounced, and during that particular ADM Jabalpur dissent, he was writing, okay, and he was talking to his sister that I'm writing this judgment probably, and I'll not become the CJI. Okay, that judgment is not pronounced, and that is the future, because he was superseded in the later phase. And during that conversation with his sister, that he is saying to his sister, okay, I'm writing this dissent of the ADM Jabalpur and I'll not become CJI, which I always wanted to become CJI, and that's why I entered into judiciary, kind of thing. This kind of conversation is there. But sister, I wanted to write this dissent because that's why I am here to hold the epitome of judiciary. And he said to his sister that I know by writing this judgment, I'll be superseded or I'll not be made CJI. Okay, but I don't care. I'll write this dissent because that is what needed the Indian people at that time. Okay. That is what is needed to uphold the Indian independence of the Indian judiciary. So these are the line of the HR Khanna while writing this particular ADM Jabalpur dissent. Okay, and that further in the future that led to huge uproar and supersession of HR Khanna, because that was the situation. And then after this supersession, then the first judge's case came into the picture. Okay, first judge's case basically is one of the very important one, either again so criticized judgment, okay, HR Khanna, yeah, SP Gupta. Okay, now so far whatever I've shared, everybody understood? Everybody understood? The tussle just started with the tug of war, just started with the union and judiciary. Everybody understanding? Everybody understanding? समझ पा रहे हो? Everybody? Anybody who's not able to understand? Anybody who's not able to understand, shall I make it understand anything? Now, the next part, okay. Next part is very, very important. Now coming the first judge's case. First judge's case is SP Gupta. SP Gupta case, which is also renowned as first judge's case. Now, I'm not getting into too much facts of this case or anything because that is not needed. What we need is the understanding what has been asked in that particular judgment. So first judge's case, the SP Gupta case, it was very famous. It was very famous and also very criticized. Very criticized because here one of the famous judge who has authored this particular judgment was P.N. Bhagwati. P.N. Bhagwati, also you might have heard the name of P.N. Bhagwati. Now, P.N. Bhagwati authored this particular, one of the authors of this judgment, okay, in SP Gupta case. Now, while writing this particular judgment, P.N. Bhagwati, he is basically focusing on two very important aspects under Article 124(2). He stated that President, after the consultation with the such judges, the appointment will be done. That was the law that is there, 124(2). President, after consultation with such judges, the Supreme Court judges' appointment will be done. As this is the law that is there in 124(2), P.N. Bhagwati took a very, very detailed interpretation of this thing. First, he said there is no primacy given to, no primacy, I'm telling you, no primacy given to Supreme Court judges in this process. Second, I'll just explain the things one after another. Write down. Consultation means just the recommendation of the legal knowledge of that person, of the person. Rest of the things will be taken care of by the president. No primacy. Consultation means recommendation of the person who have proper legal knowledge and should be appointed as a Supreme Court judge. Third, consultation is just a consultation. Consultation doesn't mean this particular recommendation has to be. Consultation doesn't mean, consultation is not mandatory. It's not mandatory on the president's choice. Four, sole authority to appoint the judge is the president and the cabinet. President and the cabinet. The Supreme Court judges, they play the second fiddle here in the whole game, only to recommend those people who have the legal knowledge, that's all. Now, P.N. Bhagwati, while authoring this particular judgment, he has seen the history of the things. He has seen two supersession of the judges are already taken place, but he has seen the history from the 1950 to 1973, what was happening. And all the time it was happening, the president, after consultation with the senior most judges, they were getting appointed. Okay. Third and fourth, yeah, Pranjali. Third is, sorry, consultation is mandatory on the president choice. Consultation is not mandatory on the president choice. sole authority to appoint judge is the president and the cabinet, Pranjali. Okay. Now, P.N. Bhagwati basically focused on this aspect and stated that whatever is happening from 1950 to 1973 onwards, the president is appointing the judges and there is no problem at all. The only problem is in relation to the two rare incident happened. One is supersession of judge in 1973 and another one is H.R. Khanna supersession of judge. But in most of the cases, president's approval and the president is appointing the judges. So the main authority here as per the article 124(2) is the president along with the cabinet, they are appointing. The consultation that is written in the Indian Constitution is just a consultation. There is no primacy here. Primacy means there is no supremacy of the judiciary is to be taken care of. That whatever the judiciary is going to say, CJI is going to suggest, that has to be listened to. SC, the Supreme Court will play second fiddle in relation to appointment of judges. Yes, sir. Absolutely. Always. That was the P.N. Bhagwati's judgment in relation to S.P. Gupta. And it was highly criticized that time. Because P.N. Bhagwati's S.P. Gupta judgment actually laid the foundation or opened the door of annihilation of Indian judiciary again. Which the Supreme Court later realized. And after 10 years, again the second judge's case came into the picture. And the second judge's case, Supreme Court totally overruled the first judge's case and changed the whole dynamics of the system altogether. Okay. Now, so far, first judge's case, everybody understood? First judge's case, everybody understood? Everybody understood first judge's case?
Yes, sir.
Okay. Now coming to the second judge's case. Second judge's case is a 9-judge bench case. Okay. सबको समझ में आया ना? किसी को नहीं सर. Ayesha, Anju, Abhishek, Kirti, Mahalakshmi, did you get it? Nimisha, Parvez, Pranjali, Rishabh.
Yes, sir. Yes, sir.
Yes, sir.
Getting it, na? Venkat, Vaishnavi, Simran, everybody getting it. Okay. Now the next very important case that happened. Now this S.P. Gupta case was not the first one in relation to this. Then came the next very important judgment, which is going to review the S.P. Gupta judgment. And that was a 9-judge bench case, Supreme Court Advocates on Record Association versus Union of India. This is second judge bench case. Okay. Now this second judge bench case changed the way what has been uttered in the last time. The very first instance, what it has done, primacy to SC. SC will be the deciding authority. Third, consultation means concurrence. Fourth, president has to accept whatever is recommended. Whoever, sorry, not whatever. Whoever is recommended by the CGI. Fifth is recommendation is now mandatory. On president choice. Mandatory is mandatory.
Sir, what is the third point?
Consultation means concurrence. Okay. In a historic judgment, by majority of 7:2, Supreme Court held that in relation to appointment of judges. Fourth is president has to accept whatever is recommended by the CGI. In a historic judgment, whoever recommendation is mandatory on president's choice. Now, this very important concept in the second judge's case. In a historic 7:2 majority, Supreme Court basically stated and snatched the independence of the judiciary from the garb of executive for the very first time, and stated, or even you can say manipulated the interpretation to extent that the consultation means the concurrence. Now you have to understand the two different words, the consultation and the concurrence. Now, suppose here in this case, think like Parvez or Rishabh. Rishabh might be, think about Rishabh. Parvez is the king. Rishabh is minister. Nobody take it personally. Okay. Now, there is a rule, suppose the king has to consult with the minister before taking any kind of decision in relation to taxes. That is the rule. Now, king has to consult with the minister. What that is mean? What does that mean? Okay, that whatever the minister or the Rishabh saying to Parvez, Rishabh will give suggestion or advice to the Parvez, but at the end of the day, Parvez as a king is going to take the decision. Yes or no? Whether he likes it or he doesn't like the Rishabh's recommendation or suggestion or advice, that's totally up to Parvez's discretion, whether to take that suggestion or not. But if the law is saying the king has to consult with the minister before making any laws or any taxes, it means that king has to consult with the minister. So these are the things that we are doing. Suppose, suggest me in this case. Okay. Now, in this situation, Supreme Court basically changed the dynamics of it. How? Now, king has to consult with the minister. Also, king has to concur with the ministers. इसका मतलब ये है, minister whatever is going to suggest to king, king has to abide by. King has to listen to. Or suppose Rishabh is Minister of Finance and Taxation. So in that department, Rishabh has the authority to take decision, and whatever Rishabh is suggesting or recommending to the king, Parvez has to abide by that particular suggestion or advice. Because now consultation is not the norm. Consultation has become concurrence. Concurrence is mandatory to follow. Concurrence means either president has to concur with the CGI. President has to concur with the CGI. Whatever CGI is going to do, president is going to concur. President just to follow the things, whatever has been suggested by the CGI. So this is basically the dynamics were totally changed. Now you might be saying, is it the real law? Probably not. Is it what needed to save the independence of judiciary? Probably yes. Okay. But that was done in the second particular judge's case. In the second judge's case, the Supreme Court or the CGI has been given the primacy. In the whole process 124(2), the primacy is given to CGI or the judiciary. The judiciary is going to take the call and president is going to play the second fiddle, or the executive is going to play the second fiddle. Understanding? Understanding here, everybody? Understanding?
Yes, sir.
Okay. Getting it? Okay. Now, in the whole theory, if सबको समझ में आ रहा है ना, second judge's case, what is going on? How the law is getting changed, how law is differently interpreted here in this case. Everybody? Excellent. Now, what basically it evolved is a participatory consultative process. Selection of the judges will be done in relation to participatory consultative process. Collegium hasn't been introduced as of now. This is the very first instance of the collegium that is getting started. Participatory consultative process is going to take place here along with the CGI, with the judges. They're going to take charge, and participative consultative process via judiciary and the executive. Whole process will be done. Okay. So participatory consultative process is basically more or less done by the CGI and the judges. Executive just has to abide by whatever is done. Okay, but not so robust collegium mechanism has started in the second judge's case. It's basically delineated in third judge's case. But the first instance of participatory consultative process in relation to appointment of judges was delineated in the second judge's case. Getting it, everybody? Everybody understanding? Everybody?
So what is the last line you said? Could you repeat?
तो मुश्किल कर दिया क्या बोला लास्ट लाइन में executive just have to
So,
mere abide by the recommendation. Yeah. Which one? Which one?
so you
Which
said
one?
that the robust Supreme Court collegium was actually introduced in the third judge's case.
Yes, yes. This part, Pranjali, could you participatory consultative process? Participatory consultative process is nothing but CJI, okay? And there is nothing. I mean, now the judges have been mentioned, okay? The judges and the president, they are going to basically create a consultative process, and that process will basically create an outcome in which the primacy is given to the judiciary. Primacy and the authority is given to the judiciary. They are going to choose, and executive just have to follow the order. That's all. Getting it? Okay. Now, the next very important part. Next came into the picture this participatory consultative process in the third judge's case becomes the consultation of plurality of the judges, and that is called the collegium. More so. Okay. Let's get into the third judge's case. Now, third judge's case is basically more robust and given a better understanding how this consultative process will be done and what would be the procedure of it. Third judge's case. Now, third judge's case, if you look at it, third judge's case, now it is coming the consultation of third judge's case. Yes. Okay. Third judge's case. In presidential reference. Okay, presidential reference. Appointment and transfer. It's regarding appointment of transfers. Okay, in presidential reference. Third judge's case. So, consultation of plurality of judges, it is going to be started with the third judge's case. Now, what is there? Now, another different layer are getting added to it. What kind of layer? The Supreme Court Chief Justice had to consult with 4 senior most judges of the Supreme Court. CJI plus 4 senior most judges. Have to consult in this case to decide in this matter. Okay. This is Very interesting. The reason being, how from the president to CJI, then CJI plus 4 senior most judges, the collegium evolved. And if two of the 4 disagreed on some name, it could not be recommended to the president. Understanding? So 4 senior most judges, very, very important in this case, in relation to whole situation. Getting it? Now the consultation becomes this collegium now. Consultation becomes the collegium in third judge's case. Okay. Now, this situation was going smoothly in 1998, 1999. That was basically sealed everything for the independence of judiciary, and the president's role is very, very minimal in this case, only to find out the person's behavior, attitude, this other aspect of a individual's characteristic that has to be checked. Most of the things will be taken care of by the 4 senior most judges plus CGI. Okay. Now, in this situation, in the next 14-15 years, everything was going smoothly. Then the 99th amendment came into the picture. What I'm saying, this whole situation was going on smoothly, Kirti, from 1999 onwards till 2010, everything was going on smoothly. After 2010, again, there is certain kind of disruption started to happen in the appointment of judges. In the appointment of judges, now there is another new phenomena came into the picture called NJAC, National Judicial Accountability Commission. Now, NJAC is going to take place during that time of 2013-14 के time की बात कर रहा हूं मैं, last 10 years, before 10 years. And this whole collegium and consultation process was heavily criticized by the executive and the media. The reason being, this collegium was highly secretive. Who was recommended as a Supreme Court judge, nobody got to know. What is the process of recommendation? Nobody got to know. Because the CGI plus 4 senior most judges, they are basically doing it behind the closed door. And that's why collegium and the transparency that don't go hand in hand. So the independence of judiciary is sustained, but the trust and the transparency on the Supreme Court under the question mark because of this collegium system. Yes, it is not subjected to RTI also. So nobody knows how the senior most judges appointed. Because in the senior most, sorry, the judges appointed. Now, in this case, nobody knows what is the criteria to become a Supreme Court judge. How to, what is the process? What is the criteria? Okay. And simultaneously, there is some kind of favoritism and partiality also seen in this whole process. Some of the judges or the basically the relative or the very closed one or the the close relation persons were given the chance also. So the executive was basically putting a question mark on the whole collegium system. That as the collegium system is directly going against the transparency of the Supreme Court, as it is one of the highest institution in Indian democracy, it cannot, or the judges of this institution cannot be appointed so secretively. People should like to know. Because of this, NJSC came into the picture in around okay 2014 via 99th Amendment Act. So 99th Amendment Act, NJSC came into the picture. And it added basically 124A, what I was showing you beforehand, this thing. Thank God this is there. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the NJSC. Refer to Article 124A. Okay. So NJSC is now going to recommend this thing. Interesting. Now, what is the composition of NJSC? NJSC composition was very, very interesting to hear, because now NJSC is going to consist of several members, and it's very open. One is CJI, one is two senior most judge. Third, law minister. Fourth, two eminent person from that domain. That domain बोलना भी गलत होगा, because NJSC judgment में उसको हटा दिया गया है. Two eminent person. Now this will basically constituted the NJSC. Parvez बताओ. Yes. Yeah.
So the problem with the fourth point is the two eminent person. It had to be nominated by a committee, and the
Yeah.
committee was consisting of the CJI, the Prime Minister, and the leader of the opposition as well.
True.
So that is what another problem was with NJSC. That was one of the
Yes.
main points.
Yes. That was also there, but Justice Keher, they basically outrightly reject this two eminent person. When you are going to understand, because I'm not getting into too many things, as you opened up this discussion, I'm telling you, Justice Keher, though there is a certain process, right? What are the person who is going to recruit or appoint this two eminent person? You said CJI, and what are the other two persons you said?
So it is a panel that is consisting of the Prime Minister, the Chief Justice, and the leader of the opposition.
Yeah.
So
So they are going to
nominate
appoint
two
the
people.
two eminent person. That is
Yeah.
there in the NJC. That is there. Who is going to be appointed as two eminent person? But in the NJC judgment, in which it is struck down, Justice Keher said the two eminent person don't have the capability to basically share this recommendation in this matter. They might be from any other background, they might be from the sociology, they might be from the economics, they might be appointed from any other domain. How do they have the knowledge in relation to law? Might not be. So how can they share their recommendation and vote in matter of appointment of judges? So it is highly arbitrary and unconstitutional in this particular to have two eminent person in this board. This is one of the things that Justice K said here. So NJSC was appointed. Okay. Now, NJC, when it was appointed, it was again just shook the entire edifice of Indian judiciary one more time. Because now what is happening, there are two people from the judiciary, three people from the judiciary and three people from the executive. And because of that, the situation happened is that again the primacy of choosing the person is not assigned or aligned with the Indian judiciary. And Indian judiciary, out of the fear of the supersession of judges, last 40 years fear that was there, they struck down the NJC because of various reasons. I'm going to quote two reasons and I'm going to read it from that judgment. उसके बारे में मैं बताऊंगा आपको, मैं उससे quote करूंगा आप लोगों को. And NJC was struck down in 2015. It was a 1,000-page judgment, and in that judgment, though the judgment was criticized, Justice Chellamaswar retained one of the very famous minority judgment in that case. But this particular NJC was basically struck down in 2015 4 judges case, and the whatever was there going on in the collegium, that was reinstated. And now in 2017, now the collegium system, the transparency, for the sake of transparency, they have to upload the data in regarding the collegium on the Supreme Court website. That was the current situation, but I'm not getting into that. Regarding the CGI and the two senior most judge, law minister and two eminent person, this NJC committee and the commission, basically, that was struck down in the 4 judges case.
So which year? So
Supreme
which year
Court,
was
yeah. What was it saying?
So which year was this judgment?
Which?
Year. Which year?
2015. Supreme Court Advocates on Record Association versus Union of India again.
So,
बताओ.
so from the composition of NJAC, in which case
Sorry.
was the criteria? So, in the composition of NJAC, in which case was the criteria of two eminent persons to be included in the constitution of the NJAC was removed by Justice Kehar?
No, I could not get you. Tell me again.
So, I'll just type it in the chat box.
Achha, I'm going to quote NJC judgment, okay, directly. One second, रुको. I'm going to quote the NJC judgment, the two reasons, because that you need to know in this case. And one second. Now, yes. In this case only, in the NJC case itself. This case only. Now, Justice Kehar basically stated that NJC was destructive of the basic structure for two main reasons. Okay. Because the first, what he stated, and which is quite interesting, you will love to see, which I told you. It was destructive of the basic structure. Mind it, it was destructive of the basic structure of Indian Constitution for two main reasons. One is it did not ensure adequate judicial and representation. Okay. First reason is this: it did not ensure adequate judicial representation. It means only 3:3 ratio is there, right? Adequate means here Justice Kher talking about the primacy or the supremacy, mind it. Second, the presence of law minister created a conflict of interest. And violated the judicial independence. The presence of law minister created a conflict of interest and violated the judicial independence. Okay. Once again. The reason is very simple, that because the government of India was party to much litigation in these courts. So these are the two very main reasons that NJSC was destructive of the basic structure called the independence of judiciary. Okay. Now, Justice Kher also argued that the eminent person clause was void for vagueness, for not prescribing any minimum qualification for such person. So this is the three very important reason he basically struck down, because he wrote the judgment here, the majority judgment, Justice Kher. He basically struck down the NJAC altogether. And he interchangeably used judicial primacy over the judicial independence. Mind it, there is a term called judicial primacy, there is a term called judicial independence. He interchangeably used it, that judicial primacy is missing here in the NJSC, and that's why it should be struck down. He didn't talk about the judicial independence here in the judgment altogether. He talks about more of the judicial primacy in the whole situation. Sir, what is the third reason? The eminent person. Eminent person. Minimum qualification is not there for the eminent person. how the eminent person who are in the panel, the minimum qualification is not there. Yes. Two eminent person. Sir, please explain the second point. The presence of law minister. Presence of law minister in the panel, that might be a situation that any particular judge who is oriented or who is, we read in, I don't know, have you, Pranjali, have you read realist law school? Have you read realist law school? कुछ याद है आपको realist law school के बारे में? Anybody has read? Not much. Okay. Anybody can remember who has read jurisprudence about the realist school? I talked about Justice Arun Mishra. Justice Arun is one of the judges who is judgment of the court is the law. Yes. Arun Mishra is one of that kind of judge who is more inclined towards BJP ideology and Narendra Modi. Now, if the law minister is going to be present in the NJAC and vote, in that case, there's a highly likelihood he is going to vote for those judges who is in favor of BJP party or the ruling party. Understanding? Understanding? Pranjali. So as a result, as the government of India is litigation to many of the parties to many of the litigations, there's a high probability if that judge will sit on that particular bench, that particular judge will favor the government of India because he is supported by the, or he is backing the ideology of the ruling party. So when I was talking about the realism, in the realism, that part, okay, any particular judge may be influenced by the ideology of any particular ideology, and that ideology might align with the ruling party's ideology, and that time that judge will give that kind of judgment which will favor the ruling party. And there are so many instances in the recent past when you are going to see the press conference that has happened, the master of roster related to that. Okay. That basically happened because in so many instances the major crucial decisions in relation to any political party that were decided or given that particular one or two judges were given that kind of cases, because that or those judges are going to give better or favorable result to the ruling party. That was happening. Yes, definitely. So this is a very important aspect in relation to this that you have to take care. And the presence of law minister will create this kind of conflict, that any judges who is going to be appointed or recommended, there's a high likelihood that that judge who is going to be recommended by the law minister is going to favor the ruling party. Getting it, everybody? In realism, when you're going to read the different, if you read Leolin, okay, that you will get to understand the ideologies, the judges' ideologies, how the idiosyncrasies of the judges that play a very important role in writing the judgment. Okay, judgment is not the legislation, but judgment is the likes, dislikes, and the idiosyncrasies of the judges that will influence the judgment. Justice Abhijit Gangapathy, you will very well see. Recently, he was joined BJP. Rohit Arya controversy recently also related to this. Yes, definitely. Yes, definitely. Are you people able to understand this part? Everybody? Everybody? Getting it? Anju Singh, could you also repeat the point regard to primacy and independence? Now, independence and primacy totally different thing. Primacy is supremacy. Supremacy doesn't mean independence, Anju. Are you understanding? Supremacy means supremacy, you have the upper hand. Independence is independence. That talks about you are free to decide. Right? So, judicial
So
primacy is
in
one of the
this,
part that has been talked about in this case.
sir, in this particular case, what did they say? They referred to primacy and not judicial independence.
So Justice Keher basically interchangeably used the judicial primacy as the judicial independence, which must not be done by the Justice Keher. Everybody got this thing? Everybody got this thing? Appointment of judges, is it clear to everybody? Is it clear to everybody? Is it clear to everybody? Was it interesting one? Was it interesting one?
So by the end of this particular judgment, judiciary's independence was upheld.
By what you are saying?
Sir, by this particular judgment, judiciary's independence.
Last part, what is it? By what? इसके बाद सुनाई नहीं दिया. हाँ, लिख लो आप चैट में लिखो. Okay. Parvez, okay, very interesting. Yeah, definitely. So, guys, everybody understood. Sanmukha Priya understood. Rishabh, Simran, Sayok.
Yes, sir. Yes, sir.
Yeah. Pranjali, Mahalakshmi understood. I hope many of you already know this thing. I just summarize the things so that you'll be able to remember this thing better. Many of you probably know these things one by one. मुझे लग रहा है. So by this particular judgment, judiciary independence was, yes, over. No, nothing really, Anju. Okay? The Justice Scale used the judicial independence and the primacy interchangeably. That's all. Nothing upheld, nothing in relation to that. NJSC was struck down, and the previous situation that was going on, that was restored, like the collegium was restored. That's all. Okay, got it. Achha. Any other query regarding this? Any other query regarding this? अच्छा, today's topic was very nice. लोग nice तब बोलते हैं जब समझ में बहुत आसानी से आ जाता है. मैं and very interesting, yeah. मैं एक हफ्ते बाद I'll start taking the Davinder Singh case. I hope this kind of word I'll hear from you. Very interesting, very nice. नहीं, it will be nice. आप क्यों रो रहे हो अभी? 500 page. You are going to read 500 page for the very first time. Okay, right. And some of you might have done it, some of you are going to do it for the very first time in your life. कि 500 page पढ़ने वाले हो, you are going to read one Jane Pandey probably, or 2/3 of the Jane Pandey in your life. when you're going to start reading that, I'll tell you. It's a very interesting one, and I'll just make sure that you'll be able to navigate the whole judgment very, very easily. So repeat the line of the collegium of third. ये तो कीर्ति जी आप तब कहाँ थे? मुश्किल कर देते हो आप. निकल गया तो निकल गया ना. CJ plus 4 senior most judge. That's all. सर हम मैसेज किए थे बट मैं देखा नहीं था, सॉरी. I haven't seen that. आप अभी probably I can hear your voice because today you can say it also, Kirti. Your voice I can hear it. I think so. You can say it.
Okay, sir.
No, yeah. This is the part, huh? That is probably I might have missed it. CJ plus 4 senior most judge. Everybody got it? Everybody got it? Next day we're going to talk about the removal. Next day we're going to talk about the removal. Okay. Sir, weekly test सीता सोरेन केस कंपनी CRPC all 3 years बेस्ट है. बहुत कम है, बहुत कम पोर्शन है, बहुत कम पोर्शन. यस, वैसे में बोल रहा सर बहुत कम नहीं है ये, किसी भी साइड से कम नहीं है सर, किसी भी साइड से कम नहीं. Yes, सिमरन जी, tomorrow you have a constant class. नहीं करवाओ? You want me not to take the class, Simran, tomorrow? ओके. नेक्स्ट वीक दविंदर सिंह के लिए रेडी हो जाइएगा, ठीक है? मजा आएगा. Be prepared and don't miss the class because 500 page judgment. Definitely, if you're going to miss it, you have to. If you're going to miss 500 page judgment, you have to read at least 2500 pages because you have to make sure to understand 10 to 15 different judgments. That's the beauty of a 500 page judgment. वो देखने में 500 पेज है but actually वो 2000 पेज है if you don't understand. सर आप डरा रहे हो, आप डरा रहे हो. Just simply you are frightening us to our court today. हाँ, definitely reservation will be cleared from that one judgment. My promise. If it's gonna take 4-5 classes, we can do it back to back. Let's see. पहले start तो करने दो. How you are going to respond उसके ऊपर depend कर रहा है सिमरन जी. मुझे नहीं पता how you people are going to respond. आप लोग कैसे respond करोगे? क्योंकि first day I'm going to talk about the problems and the laws. Second day I'll get into the judgment. तो अगर problem laws आपको समझ में आ गया, ठीक है, I can sail through the judgment, not a problem at all. और हाँ, but definitely there are so many 10-12 cases are there. Definite. NM Thomas, Indra Sahni, all are big landmark. NM Thomas, Indra Sahni, M Nagraj, Jarnail Singh, Davinder Singh Chotawala, E.V. Chinaiya. So all those judgments are there. Maybe I'm missing one or two also. Some part I talked about the group subordination theory already, but you need to understand that also probably. I don't know. I thought that I thought that it is not going to pronounce this year. Probably pronounced or coming. It is judgment was given in the month of February. Probably it is not uh, there, right? It was not. It was reserved. Yeah. नहीं ऐसा कुछ नहीं हुआ सनमुखा जी ऐसा कुछ नहीं होने वाला है अरे you were there in the article 370 ना but it was bit different ये देखो ये बहुत ही गंदा न्यूज साहेब का बता दिए द मोमेंट एनी सीजेआई इज गोइंग टू रिटायर ठीक है वो बेसिकली फेमस होने के लिए 3-4 ऐसा केस तो खोल के ही जाएगा देके जाएगा और ये आप लिख के ले लो ये बहुत ही खराब न्यूज है आप लोगों के लिए खराब न्यूज है आई थॉट के चंद्रचूड़ इज गोइंग टू रिमेन मुझे नहीं पता था उनका लास्ट ये कब है if he is going to retire in November expect some more एकदम landmark groundbreaking judgments even Patna reservation 100% reservation Patna High Court ka judgment that is also referred to Supreme Court you never know that judgment might also be there Supreme Court wala Patna High Court wala okay but if you read this judgment one reservation case everything will be solved rest of the reservation cases will be cakewalk okay will be cakewalk अच्छा चलो any other query any other query any other query are you people understanding constitution are you people understanding constitution
Yes,
Everybody?
sir.
समझ आ रहा है ना अंदर तो जा रहा है ना कॉन्स्टिट्यूशन किसका किसका अंदर नहीं जा रहा है इट्स एब्सोल्युटली फाइन यू आर नॉट एबल टू अंडरस्टैंड इट सबके दिमाग में जा रहा है बहुत बढ़िया okay so we're going to meet tomorrow talking about the removal Nivisha's acha that's great next day we were talking about the removal okay and the removal would be very very interesting we are going to talk about some very very infamous judges who were there in relation to or on the brink of removal we're going to talk about that okay so is an interesting one कुछ judges है अच्छा how many of you remember or I don't know you hear the name of Justice Katzu नाम सुने हो आप लोग हम लोग के टाइम बहुत फेमस था जस्टिस काटजू के नाम सुने हो वेरी डेयरिंग जज कहीं पर भी कुछ भी बोल सकता है ओके Kaji is infamous too. So we're going to learn about some of the infamous. So we're definitely not going to talk about Kaju. Okay. But Kaju is one of the very, very infamous. He can satire king ये सब छोड़ी दो आप satire king is one thing that you are taking down some person under the garb of satire ठीक है one thing He's not satire. Satire cannot be one thing that can go along with him. He's so open. His words are like swords, cutting the throats of the people and the hearts of the people. Okay. So मैं एक इंटरव्यू सुन रहा था काटजू के, बहुत दिन पहले की बात है, एंड जस्टिस काटजू वाज बेसिकली आई होप यू पीपल नो करण थापर, राइट? करण थापर को आपको पता है? करण थापर का नाम सुने हो? अगर करण थापर का नाम
Yes, sir.
करण थापर, तो अभी द वायर में, आप यूट्यूब चैनल द वायर में, very infamous for shutting down Modi ji. Yes, definitely. Yeah, that is. Yeah, Sayag is saying another thing. So that's a totally different incident altogether. So that you can watch on YouTube. So Karju and Karan Thapar, the conversation. Okay, and in that conversation, Karan Thapar was humiliated by Karju. One incident. Another incident I am saying, Karju was invited by Faizan Mustafa sir. Faizan Mustafa sir. Okay. This interview is there in the Faizan Mustafa sir's channel. Probably, I don't know it was taken down or it was taken down, I don't know. Faizan Mustafa sir, you know how reputed this person is in the academic field, legal academic field. Faizan Mustafa, I don't need to tell you the reputation this person holds. Okay. Justice Karju basically humiliated on his own YouTube channel. फैजान मुस्तफा सर हंसते हंसते उसको ले जा रहे। फैजान मुस्तफा सर doesn't have the guts to say anything to Justice Karju. Doesn't have the guts. He did not only rips apart Faizan Mustafa, also the entire legal academic profession. Yes, yes. So अगर मिलता है तो जरूर देखना, if that is there, फैजान मुस्तफा सर के। बोले सर, अब फैजान मुस्तफा के YouTube चैनल में, उनके एक YouTube चैनल है रिसर्व, ओके, हाँ, फैजान मुस्तफा सर के, तो if that is there, you will get that on the YouTube channel itself. Probably whole video you will find it, or some video, some part of the video that is there. Okay. आपको फैजान मुस्तफा सर के YouTube चैनल में मिल जाएगा. It is there. Okay, it's there, तो बहुत बढ़िया, आप एक बार देखना. But when you have the time to do, open it. So it's one of those judges that we will talk about in the next class. Okay, it will be very, very interesting. V. Ramaswamy, removal of the Judges Inquiry Act, we are going to talk about tomorrow. Today, we are going to end it here. See you tomorrow. Thank you, all of you. And thank you. See you again.
Thank you, sir. Good night.
Thank you, sir. Take care. Good night.
Good night.
Good night.